Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy garu to discuss the latest updates on USCIS and Department of Labor collaboration, USCIS fee increase, and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. Before starting, I would like to reiterate the disclaimer. Please note that this show is only intended to provide general information and is for only information purposes. It is not any legal advice. Sakshi TV and the agents are not responsible in any way for your actions. Use this information at your risk. Hi Prashanthi garu, how are you doing today?
Hello Andy, Ranjit garu. I'm good, thank you.
Yeah, lots of things happened in last 1 week, and USCIS, Department of Labor, executive order, lots of things. So we have a lot to discuss today. And meanwhile,
Yes,
callers, please call when
that's
you can.
true. And every week something or the other is happening, so we always have plenty to discuss.
Yes, true. That's true. It looks like every day there is something new, and every day, the government is coming up with new rules, regulations, executive orders, whatnot. So let's hope everything works good for us. So yeah, to start with, before someone calls in, I would like to ask you about some questions regarding to the U.S. Department of Labor and U.S. Department of Homeland Security entered into a memorandum of agreement where the departments will now provide access to each other and share information each other about immigrant and non-immigrant petitions. How do you think this is going to pan up? There are a lot of questions. Earlier they don't have shared any information. Now, do you think this is going to affect the immigration in any way, especially the H-1Bs and other non-immigrant visas? Will this be going to be a great impact for the employers, employees, and all?
So we have to wait and see what impact it actually has. But yeah, the memorandum that of understanding that they came to, basically the USCIS and the Department of Labor, they have basically said that they will have a common database whereby I'm presuming the offenders' information will be shared. In the past, it wasn't so, unless it was a serious offender, then of course, if USCIS was if DOL was conducting an audit, then they would share it with USCIS. And we would sometimes see I-140 denials, H-1 denials on the basis of a Department of Labor audit. But in general, that was not common. So as you know, in their lifetime, a H-1B dependent employer is audited at least once or more than once. Because that's what they're, the extra fees, the 1,500 or the 750, that's where it's going for these audits, and to make sure that the H-1B program works well and is free of fraud. So there were two types of audits, and there have always been two types. One is, of course, the audit conducted by USCIS, in which they would normally ask to see if you're compliant with USCIS regulations, if you're filing amendments, if the employee is working where you say they were working, that kind of thing. That's mostly, that was the audit. For the Department of Labor audit, it's a completely different audit. It's basically, they're only interested, they don't care about whether you're maintaining immigration status or not. They only care about wage and hour. It's a wage and hour division audit. So they only care about the LCA portion of the H-1B. So basically whether you're paying, the prevailing wages or the actual wage, whichever is higher, whether you're benching people or you're actually paying them, so whether you're maintaining your wages, basically, that's the only thing they're interested in. So if there was a complaint from an employee saying that, I'm not getting paid my wage, then the DOL would take action and there would be a DOL audit. So, and this information was often not shared with USCIS, so we wouldn't see any repercussion with, with employers getting more RFEs or an additional USCIS audit after that, or that kind of thing. So now I think if there is a sharing of information, even if there's a DOL audit, a wage and hour audit, an I-9 audit, which basically means that they're checking to see whether you're maintaining your I-9s or not, whether you're working as per your LCA work location or not. This is all DOL. So you will see a repercussion of that on USCIS H1 approvals as well, for sure.
So does this mean it could be possible that there will be more audits because they collaborated and they can share information now?
Yeah, so there are two things. One, USCIS, after DOL does its audit, and if they find some negative factors in it, they find that you're not paying or they're not working at where they're supposed to work, so the wages are affected because of that, then they will share that information with USCIS, and you can expect then that USCIS will, again, maybe FDNS will do an audit. This is the fraud, this is a contractor agency that USCIS has hired to ensure that, the H-1B, after the approval comes, the H-1B worker is being, is meeting all the requirements as per what you said in your H-1B petition. So yes, that could be a possibility. Second possibility could be more RFEs for those companies. Maybe they will send an RFE for every company, for every employee in that company, asking if, if it's an extension, for example, maybe they'll ask and make sure that the H-1B, previous H-1B maintained their status. They'll ask for pay stubs, they might ask for W-2s of the employees, tax returns, so maintenance of status RFEs might be there.
So any advice to employees and employers on this matter, that you give, like employee should have the LCA copy with him, and employee should have, all the set of H-1B that's sent to USCIS, or the employer should have these data like public access files, or something like that. Do you have any advice to them, so everyone is prepared?
So it's always the case, Ranjit, that always as attorneys we say, to maintain, to follow the regulation, and basic part of the regulation is pay your employees the way you're supposed to pay them the prevailing wage or higher, number one. Number two, even if they're on bench, make sure you pay them. Number three is make sure you maintain the I-9 files, and make sure you maintain the H-1B files. They're two different files. The H-1B files, is basically you have to make sure that you have the H-1B approvals, you have their the LCA approval, you have the posting, and you have the wage as to how you came up with the wage. You have a calculation as to how you came up with the wage. So these are the documents that you may need to maintain in your H-1B file. And then the I-9 file has to have, the I-9 which is signed by both parties, has to have documentation showing on what basis they're working. So their work documentation has to have their ID, photo ID. So this is what an I-9 file has to have. So we have to ensure that both files are complete, and we have to ensure that the worker is working as per the LCA at the work site which is mentioned in the LCA. And if there are any changes to any of this, you have to ensure that before the changes happen, you have to file an amendment. So the caution is that be extra careful, more so than before, because you can expect more RFEs and audits because of this collaboration.
Yeah, one thing I would like to ask again is, when I talk to people, a lot of people say they don't have the copy of the H-1B file. They don't have the original H-1B petition. Some people say, I don't have the LCA copy as well with me. So these are some things I hear often from people. So do you think it is mandatory for the employer to give the LCA or the H-1B petition copy or the original H-1B approval? Is there any mandate or regulation, or it's up to the employer, they can give or they cannot give?
So with reference to preventing or making these audits smoother, with reference to that, you have to ensure that, especially if your employee is working at the client side, remember the LCA has to be posted at the work site. If he's working at home now due to COVID, the LCA has to be posted at home. So you have to share the LCA approval with your employee, otherwise they may not be able to meet the regulation. Second is, yes, the employee has to know what is in his H-1B, right? What the duties are. It's a way of also making sure that you have done everything correctly. Because if you're saying that the duties are XYZ and it's something else, your employee is the best person to know, what the duties are. So unless you share the copy of the petition with the employee, they wouldn't know that. So in the least, you should at least share the copy of the forms and the petitioner letter and the LCA with your employee. The rest is, your tax returns, you don't need to share. The rest is degree copies and the employee information. So, at least share the basic petition with your employee for sure. And the LCA has to be shared, especially if they're not working from your office. And of course, the approval, with reference to your question about the approval, it's mandated that the bottom part of the I-94, the original, has to be given to your employee, because that's the I-94 which belongs to your employee. The rest of it, you can share a copy and you can keep the original unless they need the original because they're going to the consulate. But the bottom part, which is the I-94, is something that the beneficiary has to have.
True. So yeah, everyone, please make sure you follow the process and keep everything ready in case of surprise visits. You don't want to say that I don't have this, and that may give a negative impression. So everyone, please make a note of what the attorney said. Yeah. Another question we had offline from many of them is, because of this COVID, a lot of people got stuck in India or other countries and they're unable to return to US. But then the other question a lot of people had is, how many days can they work from India and get paid in US? So is there any limit that they can only work for a certain period of time when in India, when working from home? I know immigration status doesn't matter, but then let's say their H-1B already expired. Let's assume like after a few months it's going to expire. Even after the expiry, can they continue working from India and get paid in US? As per the USCIS, are there any regulations, or the U.S.D.O.L has any regulations? And IRS, does IRS have any regulations that you cannot get paid when you're out of US? Like these three questions.
So I think from the immigration standpoint, immigration has no control over anybody who's not in the US, right? So immigration, there is no impact whatsoever. You can work for as long as you want. With reference to IRS, there might be some impact for the employer, because you may not be able to pay them in the US if they're not in the US. So that of course we can't advise on, Ranjit, because we are not accountants. So you need to contact your accountant, or your employer has to contact his accountant to ensure whether they can be paid in the US or not. But there is, if they cannot be paid in the US, they can always be paid in India. Because they are in India right now. So you can, send them money to India. But again, you need to contact your accountant to find out whether you're going to pay them as an independent contractor and just send them, how are you going to show it in your taxes? Or are you going to show them, if you have a company in India, are you going to show them as employed during that time by that company in India? That is a possibility also. So you have to talk to your accountants both in the US as well as in India, and these are only tax implications. I don't see any immigration implications. You can work for as long as you want.
Okay, makes sense. Just wanted to know, because a lot of people, it could be short time because only people are stuck in India. They may be there for a couple of months and then come back. A lot of people have questions like, can I work from India because I cannot go, and can my employer pay me? Yeah, these are some questions. Yeah, that's kind of, yeah, please talk to your CPA in US and CAs in India, and then, figure out the tax implications. Apart from that, immigration has nothing to do when you are not in US. So US laws or immigration laws doesn't apply when you're not in US. That's what it is, right?
Correct.
Okay, it was nice. So yeah, the other one I wanted to talk to you about is the executive order that the president has just signed a few days back. Especially, I think this is targeted towards the TVA, but the executive order says aligning the federal contracting and hiring practices with the interests of American workers. So there is some language in that which says that Department of Labor will finalize a guidance to prevent the H-1B employers from moving the H-1B workers to other employers' job sites to displace the American workers. So this language, I think it's in section 3 of the executive order, which is kind of confusing and in a very broad spectrum, could affect a lot of people. What do you think these implications will be for the H-1B employees and employers, especially people who are working with the federal contracting?
So there are two aspects to this executive order, right? One of them is asking the the government to look into the federal contracts and asking them to look into who these contracts are going to. If these contracts are going to H-1Bs, even if it's on a secondary basis, for example, there might be a vendor in between, and then the actual employee is a H-1B. So even if it's a subcontract or whoever it might be, or how many other layers there might be, who's the person finally working on the contract? Is it a H-1B? If it is, then they're asking them to examine within 120 days whether that H-1B has displaced any US workers, whether there are any US workers available for the job. So they're asking them to look closely into this as to who the federal contracts are being awarded to and whether that can be avoided. They're also asking them to look into whether the federal contracts are being sent outside the country, whether they are being outsourced. So these two things are being looked into. And if they find that there's any displacement, I guess the contracts from those people will be pulled from those companies, and they will try to give it to someone who is, a US citizen. But the key in this, Ranjit, is in most instances, US citizens are not available to do the job because no one really wants to hire contractors and go through the entire process of immigration. So in most instances, permanent residents, US citizens are not available, especially for, entry-level jobs. And that's why, other sources are being looked into, other resources are being looked into. So there are some exceptions, of course, and, Disney was one of those exceptions, where Disneyland basically fired all their permanent resident and US citizen employees and hired, H-1Bs. But that doesn't happen often. So I think even if they go into it and they look into it, I don't think any US citizens are generally displaced in this situation. So I think it should be okay, even if they look into it, but time will tell. And also, I'm not very worried about this part because, 120 days, anything can happen. The present administration may or may not be there. We'll know. Yeah. We'll know in November.
It's 90 days exactly from today.
Yes, exactly. Yes. So I am not concerned about that right now, the first part of it. But the second part of it, which is, they say they have 45 days, I believe, to look into this. Yes. So they're asking the Department of Labor to look into the LCA regulations again. And they want to make sure that those employers who are H-1B dependent, that is, who have more than 50% of their staff on H-1, they want to make sure they're compliant with the advertising requirements. So they want to make sure that they are trying to recruit US workers before they actually hire a H-1B employee. Now, so far, but again, I'm not that worried about this as well because if you are exempt, so which basically is very easy to be exempt nowadays, because exempt employee is an employee who earns more than 65,000. Prevailing wage is more than 65,000 for most specialty occupation positions. And if you have a master's degree, either one, you're exempt and you don't have to show the advertisement, or you don't have to show that you have not displaced a US worker, or you have tried to hire a US citizen before, hiring a H-1B. So I'm not concerned about either one of them. Hopefully it won't have much impact on, the H-1B filings.
Okay, got it. And the other thing, the rumor that's going around, especially in the areas of DC, Virginia, and Maryland, there are a lot of federal contractors that work there, especially people on H-1B through contracting process, on a third-party location or like a full-time basis when federal agency gives them contracts. So these people are so worried about what's going to happen. Are they going to lose the jobs, or is it only going to be like for the new recruits, or how does it work actually?
So the scope of it has not been defined, right? They have only said, look into it and take some action. They have not by themselves. The White House has not by itself suggested what needs to be done. They've asked them to examine it. And again, the fact that it is 120 days out is something that we don't need to worry about right now, because again, the elections come, and if the new administration comes in.
Sorry to interrupt you, Prashanthi garu. There is a caller, Manohar Reddy from Dallas. Let's take the call and then we can continue it. Hi Manohar, how are you doing? You can ask a question.
Fine, sir. సార్ నమస్కారం అండి. నా పేరు మనోహర్ అండి. నేను ఇక్కడ హనుమాన్ టెంపుల్కి పనిచేస్తానండి. నేను R1 వీసా మీద పనిచేస్తున్నానండి. ఈ ప్రజెంట్ సిచ్యువేషన్లో వాళ్ళు నాకు గ్రీన్ కార్డ్ చేయడానికి కొద్దిగా సహకరించడం లేదండి. నాకు మే 31కు నా R1 వీసా అయిపోతుందండి. నాకు ఇంకా వేరే ఏదైనా సోర్స్ ద్వారా గ్రీన్ కార్డ్ చేసుకోవచ్చా? ఇంకేదన్నా విషయాలు ఉంటే చెప్తారేమోనని ఫోన్ చేస్తాను.
R1 మీద ఉంటే వేరే స్టేటస్ కి చేంజ్ చేసుకోవచ్చు. మీరు మీ టెంపుల్ తోనే మీరు మాట్లాడి వాళ్ళతోని. అదే R1 ఎక్స్టెన్షన్ అన్న, మీకు R1 ఎక్స్టెన్షన్ అన్న కావాలి, లేకుంటే మీరు గ్రీన్ కార్డ్ అన్న అప్లై చేసుకోవాలి. మీ R1 ఎక్స్టెన్షన్ అయిపోయిందా సెకండ్ టైం?
అయిపోయిందమ్మా. ఇప్పుడు నాకు మే 31 తోటి ఇక మొత్తం అయిపోతుందమ్మా 5 years టర్మ్.
అదే ఇక మీరు మే 31 అంటే అయిపోయింది కదా ఆల్రెడీ.
అంటే 2021 మే 31.
ఓకే నెక్స్ట్ ఇయర్ మే 31. ఓకే, అయితే మీకు కొంచెం టైం ఉంది. మీరు అంటే నెక్స్ట్ ఇయర్ వరకు వాళ్ళు ఫైల్ చేస్తుండొచ్చు. ఎందుకంటే ఈ ఇయర్ మేబీ బికాస్ కోవిడ్ గురించి మేబీ ఫైల్ చేస్తలేరేమో. మేబీ నెక్స్ట్ ఇయర్ ఫైల్ చేస్తారేమో. అది మీరు మాట్లాడుకోవాలి మీ టెంపుల్ తోని. బట్ ఒకవేళ అది కాకపోతే వేరేదంటే ఓన్లీ థింగ్ మీరు చేయగలిగేది B2 మీద కన్వర్ట్ కావడం. B2 అంటే బేసిక్లీ విజిటర్స్ వీసా. మీరు విజిటర్ వీసా మీద మీరు పని చేయలేరు, కానీ మీరు ఉండొచ్చు ఈ కంట్రీలో. సో అదొక్కటే మీకు ఒక మార్గం ఉన్నది. ఇంక వేరే మార్గాలు ఏవి మీకు పాటించవు, ఎందుకంటే మీరు స్టూడెంట్ గా ఉండలేరు. వర్క్ వీసా అనేది
వేరే టెంపుల్ ఏదైనా చేస్తే ఏదైనా ఆప్షన్ ఉంటుందా ప్రశాంత్ రెడ్డి గారు? వేరే టెంపుల్ వాళ్ళు దీన్ని తీసుకొని మళ్ళీ గ్రీన్ కార్డ్ ఫైల్ చేయడం అలాంటి ఆప్షన్స్ ఏమైనా ఉంటాయా?
వేరే టెంపుల్ కూడా గ్రీన్ కార్డ్ ఫైల్ చేయవచ్చు మీ కొరకు. ఒకవేళ మీరు క్వాలిఫై అయితే ఆ టెంపుల్ కూడా క్వాలిఫై కావాలి. ఒకవేళ అయితే అది కూడా మీరు చూసుకోవచ్చు, మీరు జాబ్ చేంజ్ చేసుకోవడానికి.
అమ్మా ఇంకా వేరే ఏదైనా ఉంటుందమ్మా? ఏదైనా సిటీ ఇట్లా ఏమన్నా హెల్ప్ చేయొచ్చమ్మా?
ఏది? సారీ,
ఎనీ సిటిజన్ ఆఫ్ US మాకేమన్నా హెల్ప్ చేయొచ్చమ్మా?
అట్లేం ఉండదండి, అన్లెస్ దట్ పర్సన్ ఇస్ రిలేటెడ్ టు యూ, ఇమీడియట్ రిలేటివ్. ఫర్ ఎగ్జాంపుల్ స్పౌస్ అయినా పేరెంట్ అయినా అట్లా ఉంటేనే వాళ్ళు ఫైల్ చేయొచ్చు, లేకుంటే అది మనకు యూస్ఫుల్ లేదు.
ఓకే అండి మనోహర్ గారు. సో మీరు ఈధర్ కొంచెం వెయిట్ చేసి వాళ్ళతో రిక్వెస్ట్ చేసి చేయించుకోండి మే వరకు, లేదంటే వేరే టెంపుల్ వాళ్ళు ఎవరైనా మీకు స్పాన్సర్ చేయగలిగితే మీరు ఆ ఆప్షన్ ఒకటి చూసుకోండి. థ్యాంక్స్ అండి, థ్యాంక్స్ ఫర్ కాలింగ్ ఇన్. Sorry, to continue the previous conversation that we were having, so is this, I mean, are the employees who are already working with the federal government, is there anything that they should be worried?
At this point, no, there is no point in worrying. ఎందుకంటే ఇప్పుడు so many things are happening that it's difficult to keep track and we can't worry about everything. This is a potential thing that's might happen. It's not something that has happened. Until it actually happens, obviously you don't worry. And also it is, he's given plenty of time to look into it. And again, because of the elections, that's another reason that you might not need to worry. And most importantly, Ranjit, they are saying only if someone has been displaced in a particular job, if US citizen is available. So they might change the way things go moving forward, in the sense they might do some kind of advertising requirement to make sure that there is no US citizen available.
You mean
for the
like
job.
labor, the POMA labor
something
concept?
Maybe some kind of they'll ask these federal agencies to go through some kind of a recruitment process, which they already do anyway, right? They advertise it on their website.
Yes,
they do a regular recruitment process, and they don't favor H-1B candidates over green card holders.
Most
they
of
just
the federal
need a person.
contracts even need clearance, actually, to be frank. A lot of federal jobs
Correct.
need a security clearance, which only, I think not even green cards could clear that, only citizens are eligible.
Some federal jobs are like that, some are not. But even those other jobs, I don't think they're going to restrict it to citizens or permanent residents because there's no security concern. But that was one thing that they mentioned. But if the jobs that are require certain security level clearance anyway are not given to non-immigrants. So it'll be interesting to see what they're going to come up with. And if they come up with something which is again unfair or inequitable, there are always the courts that we can approach. So I think don't lose heart right now, just wait and see.
Yes, true. And the other thing everyone is interested in, USCIS recently announced that there will be an increase of fees for a lot of immigrant and non-immigrant applications. Especially there is a huge change for I think the asylum applications where there were no charge, I believe, in the past, and it's going to be a huge money for them where they cannot even afford. That's one thing. And do you think this is the final call from USCIS? Are there going to be any changes in that? When is it going to be effective? Can you please shed some light?
Yeah, so it's going to be effective as of October 2nd. And there's some huge changes in some applications and not much change in other applications. So for example, to just get it off the bat, H-1B, there is no change. So that's a good thing. But for your 485s, adjustment of status, it's deceiving
Prashanthi
because it
garu,
actually...
sorry to interrupt
Yes.
you. We have a caller, Chandu from Oklahoma. Let's take the call and then we will resume the discussion. Hi, Chandu. Welcome to the show, and you can ask your question to the attorney. Yeah, please ask your question.
Oh, hi.
Hi.
Hey, my name is Chandu. I'm from Oklahoma. Hey, I have a couple of questions right now. Currently, my wife's, I got my H1 got approved, and my wife's H4 is still pending for the biometric because of the recent COVID situations. Many of the offices are closed, and they just started, and I think most of them are opened by end of last month. So is there any way that we can prioritize the situation? Even when I try to prioritize the situation, they rejected my case. So if I go through you guys, is there any way that I can get this biometric and everything get sorted out?
So unfortunately, attorneys can't work any magic. If you have already asked for, there are very few exceptions for them to expedite your case. It has to be life and death. Otherwise, they will not expedite because there are thousands of H4 applications, unfortunately, right now. So simply saying that, I know it's a big thing to lose a job, but simply saying that I'm going to lose my job is not enough in their minds.
Yeah, even I explained. I explained everything to them. Yeah.
Right. So the only way now is to file a court case, and I've been saying this over and over again. You have to file with district court, and you have to say that it's been pending for X number of months or whatever, however long it's been pending for, and you basically have to prioritize it that way. You can ask the court to step in because USCIS will not, and you can also join the application that AILA has done, and several other attorneys have filed lawsuits on this. You can join those applications, and in which way then it will be much cheaper for you because then you're not the only person in the application.
Okay.
Okay, thanks for calling. We have another caller, Yashwant. Let's take the call from Yashwant. Yashwant, are you online?
Yes, this is Ashfaq from California. So this is regarding E3 visa. It's totally different than the H1. So are you good to take the questions on that before I can?
Yes, attorney attorney can answer any immigration question. You can go ahead.
Okay, thank you so much for that. Yeah. So recently I have applied for my E3 renewal on site. I usually do it offshore. It was more convenient for me. But this is the first time I have done it onshore, so it is taking a bit of time. So will that be again considered as a H1 visa, or will that be getting any priority for that? And my second question is for H1. If somebody got the H1 for the change of status, can we do it while we are on site? Is there any possibilities or any process you can explain to me? Those are the two questions. Yeah, if you can answer, please.
So your E3, you said two things. One is that, what was your question about the E3? You said you're worried about the E3 because
he always got
it's been
E3
like
stamped at
almost,
the consulate, it seems, and this time he want to get it extended within the country, and he's asking if is it going to have any priority over the H-1B, or how does it work with the E3 visa within country?
So my question is, like, I used to do it offshore, is to travel and get it done. This time I have applied online, so it was more than 3 months. So will that be because of they have? Is that because they're taking it as a H1 visa as well? They consider this E3
no,
as an
H1 has
H1
nothing
visa?
to do with E3. E3 is different and H1 is different. You have to go to check
Okay.
the processing time for E3 to the service center that you sent it to, and you can follow up, or your employer can follow up with reference to your E3 petition. Since it's an I-129 petition, I think you're
Is there a
eligible for
premium?
premium
Yes.
processing. I'm not sure, but
No,
we
they're
have to
saying
check
it is
that.
not possible for premium. Yeah, it is not possible for the premium. It is separately
Right.
E3 visa, so there is no premium for E3. Yeah.
Right. So you have to follow up with USCIS, and it has nothing to do with H-1B processing. I mean, in general, processing has been delayed due to COVID and due to the impending layoffs. In general, there might be some delay in processing time, but I think you need to follow up. Have your employer follow up with USCIS.
I believe they can work on the receipt, right? Like the H-1B.
No, but this is an
Yes,
extension. So AC-21, AC-21 doesn't apply to E3s.
So they
It
cannot
applies
work
to
unless they have the
Hs.
approval.
So you can't actually work. You have to actually wait for the approval. It doesn't apply to you. Only Hs, unfortunately.
Oh, okay. And for the H1 conversion, so if I got approved for status change, so do you have to be on site? Can we do it on site? What are the chances?
You can file for a change of status from E3 to H1. But in order to do that,
E3D conversion to H1 is approved, but I want to do the change of status. For some circumstances, I haven't traveled outside India, outside America. So is there any way I can do it on site for E3D to H1?
That's what I am telling you. That's what I was answering your question. To change it, if you're filing a change of status from E3 to H1, you don't need to leave the country because you can file a change of status. And if the change of status,
in the approval,
if the change of status is, go ahead.
Yeah, in the approval letter, they said it as Chennai as a location. So I spoke to my attorney. He said he haven't heard anything back from them. It's been almost from February we've been chasing. So I haven't heard anything back from my attorney nor from the UCIS. So
your facts of your case are not clear. First you said you filed an E3 extension. Now you're saying you're filing a change of status from E3 to H1.
Looks like his H-1B is approved, but it is approved as a consular process. So he has followed up with the USCIS. So
if you can reiterate your facts clearly and then ask your question specifically, that will be easier for me to answer.
Yes, madam.
Is it an E3 extension that you're asking me, or?
Not to confuse you. Let me finish. My first question was E3, that's for me as a primary applicant. When I said E3D, that's a spouse. So the first question you have answered, I'm really thank you for that. The second question is related to E3D. So H1 got
I didn't hear that part. Okay.
E3D. Yeah, so I was trying to put that E3D.
So you filed a change of status from for your spouse from E3 to H1. Is that correct?
Exactly. Yeah.
And was it approved? The change of status was approved or not approved?
It was approved in February. The state we changed it to the status, but to get it stamped, they're saying that we need to travel to Chennai as a port of entry. I don't know where they got that information. I have to go to Chennai because
so why do you need to? So my question to you is, if the H1 has come with an I-94, why do you need to get it stamped? Has it come with an I-94 attached at the bottom or no I-94?
I-94, no, they haven't attached because it was lodged in 2008. Now they got approved in H1.
So there was
2018
no
we have applied.
I-94 attached to your E3 approval, to the H1 approval, sorry.
No, nothing. No information is attached there.
Have you looked at the original which comes to the attorney?
Yeah, they have fax. They have sent us the original one to my address. So, can you take up this one offline? I can contact, or if you can get.
Yeah, I think it's better because your case is. We need to talk to. You need to talk to me separately. I think it's a little complicated, and because I need to know why the change of status was not approved.
Yeah,
and if you go to the consulate, then maybe you can go to Canada. Yeah, I'll talk to you offline about this.
Yeah, please, anyone, if you want to reach Prashanthi Garu for a private consultation, please reach Prashanthi Garu at 212-354-1010 or email at prashanthi@reddyesq.com. Please reach out to Prashanthi. There's another caller, Chendu. I think he called in previously and got dropped. Chendu, are you online?
Yeah, I'm here.
Yeah, you can ask your question.
Hi, I have a question. I just transferred my H1 to a new client. Earlier, I was working for an employer. Right now, I transferred to a client for a full-time opportunity. And so far, I have a good rapport with my current employer. If I, can they hold my H1 even after I transfer to these guys? Can they hold for a longer time, or do they cancel my H1? What happened to it?
So you're saying you filed for a transfer, but you want to still keep the previous H1 alive?
Yeah, is it possible? If I want to, because if any dates got moved, recently I heard there's going to be a big change in USCIC that they're going to move the dates. I'm not sure. So, do they can hold the visa, my previous file?
Right. I mean, there are many ways of doing this. To answer your question, and we can talk about the dates later, but to answer your question, if you're not working on the H1, your employer is obliged, as per USCIS regulation, to withdraw your H1. So they are obliged to do that. That is the law. If they do it or not, that's a different story. Whether they are willing to take that risk and not do it, that's really up to them. But by law, they're supposed to withdraw your H1 if you're not working for them. So that's the story with that. And you can't just, if you filed a transfer, then again to move back to them, you can't just move back to them without again filing a transfer, right? Because your status has been changed now. You have asked for a change in status, a transfer to another employer, employer B. In order to change it back to A again,
I didn't start it yet.
that.
I didn't start it yet in the new employee.
Even if you didn't start, if the case was approved, that has already been established. Okay. Your transfer of employer has already been done, even if you didn't start working. And you're supposed to start working as soon as the approval comes in, right? So one way of making sure your priority date is not affected is filing labor cert and I-140 and maintaining the priority date through your present employer. That's possible, as you might know. And if for some reason the priority date becomes current through company A, then you can file it even if you're not working. You can file a 485, right? And then you can start working for that company A, because it's a future job offer. You can start working for them on the EAD once you get the EAD. So that's possible also.
Okay, there's another caller. Okay, nice talking to you, Chandu. There's another caller, Shekhar. Hi, Shekhar. How are you doing?
Hi, I'm Shekhar. I'm doing good.
Yeah, you can ask your question to Prashanthi Reddy Garu.
Yeah, sure. Hello, Prashanthi Reddy Garu. First of all, thank you very much for doing this show. It's really helpful. We're learning a lot. So, coming to my question. I know it may not be really appropriate right now, but if at all we go for a stamping outside US for an approved 797, I know India is the best place to go, but for some reason, if I have to choose between Mexico or Canada, is that a wise idea, or it's better to avoid it? Not this year. I know that this year they've stopped it, but in the next year, whenever it opens up, is there any risk going to Mexico or Canada, or what is your advice on that?
A lot of people are doing that. If you want to get your visa stamped, you're, I think, better off. If you need to, for some reason, travel, I would avoid against it. I would advise against it until this COVID situation goes away, which is next year. I would advise only traveling if there's a life and death situation. Otherwise, don't travel. Because what's happening with these presidential proclamations every day, every week, there's something new, and they keep broadening the scope of who is affected and who is not affected. So you don't want to be stuck outside the country and the proclamation comes saying that you're somehow affected. And even with reference to the present proclamation, they keep broadening the scope of it. First, they said that people who had a valid visa are not affected by it. Then they said that if you had a valid visa but it expired subsequently, you're affected by it. So they keep changing the people who are affected, the scope, they keep broadening it. So first thing is you shouldn't travel, but if you have to, then yes, you can go to Canada or Mexico. I wouldn't recommend one over the other. Mexico might be better because there's no quarantine problem at Mexico. But remember, both the northern and the southern borders are closed right now for road traffic. But you can go by flight. But for road traffic, they're closed. If you go to Canada, you have to quarantine for 2 weeks. But what people are doing or trying to do are they're trying to do flag polling. Flag polling means that you enter into the country and the same day you come back after applying for a visa or trying to get a visa. So you don't have to go through the quarantine in Canada. But you need to find out from the post, wherever you're going, you have to find out clearly what the regulations are, whether you can, what they're doing right now, whether they're open or not, whether they allow you to go to, enter and exit without a quarantine because you're, at the airport itself. So these are the things you need to find out, of course, before you leave, or maybe contact an attorney, and maybe I can help you with that, who does, consulate work, and, take it from there. But as of now, I think you shouldn't travel unless it's an emergency.
Yeah, definitely. Okay. Thank you so much.
You're welcome.
Going back to our discussion, Prashanthi Garu, so this H-1B fee increase, so, there is H-1B or a lot of USCIS fee increase. I believe H-1B is not being affected, but there are other items or other forms that are being affected. So is this, the fee increase final by USCIS? Are they going to, are still any showstoppers?
No, it's pretty much final. They have published the regulation. They have said when the effective date is October 2nd. So the main forms that might affect us is, number one is adjustment of status, the 485. That is actually going down by $10, but that is deceptive because what's happening is that they are adding a fee like they used to before, and then they changed it. But they're doing a separate fee for the 765, which is the EAD and the advanced parole, which earlier you didn't have to pay if you're filing it with the 485. So the fee actually goes up from 1760 to 2,860. So that's a significant change in the fee if you're applying for EAD and advanced parole. If you're not applying for EAD and advanced parole, the fee is gone down, actually goes down by $10. The other big whammy is for the naturalization, the N400s or citizenship. The fee has gone up by 83%. So it's almost, doubled. Yeah, that's a huge thing. So this is really surprising because most often the administration wants to make, naturalization or citizenship as easy as possible. Simply because, it's an election thing. It's, it's a political thing. More US
already
citizens.
USCIS is in deficit as well. So
yeah, but still the politics override it. But maybe the present administration thinks that the people who are going to apply now will all be Democrats, because, that's been shown most immigrants or people who are immigrating are at least start off by being Democrats. And also because the present administration has such an anti-immigrant stand, maybe they're expecting that, and that's why they've increased the fee for the naturalization. Otherwise, it's very surprising. So the
Sorry to
naturalization fee
interrupt
has.
you, Prashanthi. There is another caller. Let's take the caller. Hi, how are you doing? You can ask your question.
Hello there. Thank you so much. So myself, Sandeep Yadav, calling from California. So my question is, I've been on the H1 from 2011 till last year, and I changed my status to currently to O1A visa, which is approved till 2023, 3 years. I got it on just in April 2020. So the question is, I'm kind of considering to change my O1 to another company. So do I need to transfer that, or can I have two O1 visas? Is the question.
Yeah, so an O1 visa can be transferred. You have to file, it's the same I-129 form that you used previously, but you have to establish again that you qualify in whatever you're doing for the new firm. New company also qualifies for an O1. So you have to go through the process again. You can file a transfer.
So,
yeah.
Oh, so my question is, if in the process of transfer, if it get denied, that's my scary. So can I keep my existing O1 currently running like this, and can I ask my new company to file a new petition? So just in case if the new petition gets denied, still my current O1 will be there, so I can be on the visa legally. So that's the question.
So that is not, you don't need to worry. You don't need to worry about that, because as per USCIS regulation, if a petition is denied, then you don't automatically lose your previous status. Your previous status is status quo. So your status remains whatever it was earlier. The only issue occurs is if, so that continues to remain the previous O1. So if the new O1 is not approved, the previous O1 continues.
Oh, that's something great news. And at the same time, I'm in the process of applying for EB1A, I-140. So can I file like all at one time before these prices are getting increased in October, I believe? So, or is it advisable, let me do one at a time?
So your EB1 has to be based on the employer where you're presently working.
Oh,
so you have to decide first where, you have to decide where you want to file EB1, whether it's the previous one or the next one, company A or company B.
Oh.
So if it's with company B, then you have to file you're better off filing the O1 first, getting it approved, and then filing EB1. That's my advice.
I see. And actually one last question. Thank you so much. I'm planning to file myself EB1A petition, because I have Indian National Awards, and also in total I have about 8 hackathon awards, citations, everything. So I'm thinking better to file myself EB1, because my employer, they might take time. That's what I came to know. So so your suggestion, let me do one at a time. Let me do my own.
So if it's a national interest, okay. So if it's a national interest waiver that you're filing, you're self-sponsoring, then obviously the criteria for that is the highest when you do that, when you're doing EB1 NIW. So you have to ensure that you meet that criteria, but it's always advisable, just as a common sense matter, to file it in the easiest way possible. Both are EB1. Both have the same priority date. So why don't you go through EB1 through your employer rather than doing national interest waiver, unless your employer is not willing to file the EB1. I would say just go with the easier route.
That's the reason I'm planning to file other O1, because my current employer, he is asking me to wait for another 1-2 years to file EB1. That's the reason I did an interview, and the job, everything is there. So now my question was in a dilemma. Should I transfer from A company to B company, then go for EB1, or then I came to know as I can also do the self-petition. So that's the circle of the loop. I was in confused mode. If not, I don't want to change at this point, but waiting for another 2 years, and based on
So, I mean, there's one way
And
you can do it is maybe file an EB1 and see if it gets approved through your present, by staying at your present employer. If it gets approved, good. There's nothing further for you to do. If it gets denied, then you'll have to transfer and then file through. So what is important is also your employers, whether employer A is better than B or more well-known, or if that makes no difference, then it's up to you. It's a hard decision to make. But but there's no risk in it, even if you change your employer, because if the EP1 gets if the O1 gets denied, you still have your present O1, which is not affected. So that's something that you have to weigh and decide.
I would like to reiterate the disclaimer again. Please note that the show is not intended to provide any legal advice and is very general in nature, and it is only for informational purposes. Sakshi TV News, our agents are not responsible in any way for your actions. So use your information at your own risk. And if you want to reach Prashanthi Reddy Garu, the attorney, for any private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. Yeah, going back to our H-1B fee increase thing. So can you explain some major increases or differences?
Yeah, so again, going back to the fee thing, as we were talking, the naturalization fee has increased. DACA, which is Dreamers, the fee for the Dreamers, that has not increased. In fact, it has decreased. The other fees basically is, family-based petition I-130 increased slightly by 5%. And we talked about citizenship. So pretty much those are the main fee hikes, I think, that we need to be worried about.
Okay.
The 485 naturalization. Yeah.
There is another caller, Prashanthi Garu. Let's take the caller. Hello.
Hello.
Yeah,
Hello.
you can ask your question. Prashanthi Reddy Garu is here.
Yeah, namaste, Prashanthi Reddy garu. I have one question. Recently, my I-140 is approved from my employer. If assume that if I want to change to other employer and keep this I-140, somebody is saying that there is a 180 days lock period. So is it correct, or can I change after 1 or 2 months?
So there is no 180-day lock period. If you want to change your employer, you can change, and that doesn't affect your I-140 approval, in the sense that you can still use your I-140 approval for porting the priority date. You can still use that I-140 to extend your H-1 beyond 6 years, even though you're not working for that company. And you can still use that I-140 even if the previous employer withdraws or revokes your I-140. So you can use it for those purposes. It does not in any way get cancelled, or the priority date is retained.
So the same I-140 will carry for the next employer also. So no need to initiate new GC process. That's correct, right?
So you need to initiate the new labor cert and file a new I-140 for the new employer, but the priority date of the previous I-140 can be carried over to the new I-140, even if the previous employer withdraws it.
Okay, so I need to initiate a new GC process, like labor perm approval and I-140, and the total process needs to be initiated at the new employer.
That's correct.
Is it? Oh, okay. But priority rate is, I can keep the same priority rate. What is
that
the
is
earlier
correct.
I got it?
Correct.
Okay.
Yes.
Okay, thanks for calling. So Prashanthi, the same question is being asked by many people. So we know I-140 date can be ported when you change the employer. But the other question a lot of people have is, let's say the current employer is not filing or willing to file at this point, or let's say they want to file after a year or so, and by the time the priority date becomes current. So we can still, the previous employer, if he had not withdrawn the I-140, they can still file for a green card petition, right? Because it's a future employment.
Yes. So, but the thing is that if you have two I-140s, your question is if you have two I-140s, right? Two I-140 approvals. Is that your question?
No, current employer has not filed, but from previous employer they have an I-140 petition, and now the date has become current.
Right. Okay. So yeah, so in that situation it's easier because yes, there's no issue. You can file, the previous employer can file your 485. I mean, 485 is an application that is you file yourself, but you have to show that you still have, your employer is still willing to support you for your job to get you the green card. So you have to file, now there's a 485J that has to be signed by your employer. So yes, you have to have a valid job offer even at the time of filing 485, and it doesn't mean that you have to be working at that job right now. It could be a future job offer. But my suggestion is to start working for that employer at least once you get the EAD, so that you don't have a problem getting your green card. Because if you don't work at all for the employer, then they're going to question as to whether you even intend to work once you get your green card. And where is the proof that you will work where is your intention? You're not showing that intent to work. Because you can work really once you get the EAD. So I suggest you at least start working once you get the EAD.
There is a last caller from LA. Let's take the caller. Hi. Hello. Are you online?
Yes. My name is Sandeep Yadav. And so actually my daughter has a medical incident. She broke her arm. And my current employer, actually, I don't have a pay time off. So is there any legal law or something where I can stay with my daughter for a month without paid on my H-1B?
Yes, that's a very good question. You can apply for unpaid leave and show medical reasons, and you do not use your H-1B status because you're on leave for family emergency. So yes, that is absolutely possible, and you don't lose your H-1B status even though you're not being paid.
Because my renewal is about to come in next 2 months, so I need to submit the paid slips and for last
you can show
months,
show the leave letter. You can show the leave letter that you have taken leave due to family emergency. That is allowed.
Okay,
by
that will be
USCIS.
helpful. Thank you. Because mom is in India and she broke her arm 2 weeks back, so I need to support her. Okay, thank you so much.
You're welcome. Take care.
Okay, yeah. I think, coming back to the previous question, we only have a minute or two left. So let's say hypothetically, previous employer I-140 is not withdrawn and we can use it. And the other question I have is I-485 can be filed by employee, as you said. So can that employee file it himself using the previous I-140 and current employment?
No. Because basically what you need to do is get an I-140 based on your current employment. If you want to use your current employer, you have to get an I-140 approved based on your current employer. You can port the priority date, then you can file the 485 based on
that's
current.
About a year process. So either you go to previous employer.
Otherwise you have to file based on your previous job, previous employer. And then again start working on EAD. So you'll have to choose one way or the other.
Got it. I also heard another thing that if your previous employer had filed it and it's pending for 6 months or so, the second employer can take over.
Once the 485 is filed, yes, then there's after 6 months, yes.
So the other option is if he files and it's still pending after 6 months, then the other employer can directly take over.
Correct.
From the I-485 process. No need to file the I-140 and all.
Correct. Yes. Once the 485 is filed, yes, and 6 months have passed, then the new employer can file a 485J.
But I heard that it has to be like similar job. Is it the requirement?
Yeah, similar job within the same SOC code or similar SOC code.
Okay. So let's say if he is a Java developer or a .NET developer, it should be like same Java or .NET developer, not some other.
It could be I would say it could be anything within the IT field. It could be a systems analyst, programmer analyst, The job titles are so generic nowadays, so it can be within that field. It can be anything.
Yeah. Okay. Got it. That's one question I had. So yeah, and other thing I wanted to ask you about the H-1B fee increases. I heard that at this asylum, there's a lot of fee increase which they cannot afford. Is it true?
Yeah, asylum cases, yes. Again, they're trying to ensure that less and less people apply for asylum, and basically it's been the present administration's that it's been their motive to reduce asylum seekers. So that is, we know that for a fact. So yes, there were some instances where asylees didn't have to pay, and now they have to. So yeah.
Okay. I think we are almost at the end of the show. I would like to reiterate the disclaimer. Please note that the show is only intended to provide information and general in nature, and we are not responsible in any way for your actions. So please use at your own risk. And the other thing, if you want to reach the attorney for any private consultations, please feel free to reach her at 212-354-1010 or prashanthi@reddyesq.com. I repeat, 212-354-1010 or prashanthi@reddyesq.com. It was very informative session today, and we have a lot of callers as well. Thanks a lot for taking your time, Prashanthi Reddy garu, and in helping the community in keeping up with the updates, which a lot of people, a lot of attorneys don't take their time. I really appreciate what you are doing here, and all the callers and viewers are watching the show. Thanks for all your calls and all. It was a very great session with interesting topics. Keep calling and ask such questions, and keep yourself updated with all the immigration things that's happening around. Please call in every Wednesday at 6 p.m. Eastern Time to watch the Immigration Talk Show by Prashanthi Reddy garu. Again, it's every Wednesday, 6 p.m. EST on Sakshi TV. This is Ranjit signing off.
Thank you.
Thank you.